backtrack. And you should have kept my name out your mouth. As we go, how it all turned out. When you try to use my name for clout, keep on going, give me something you can talk about.
Hello, everybody. How are you doing this fine? Thursday, December 4th, 2025. So today I have a little bit of update on the Tory Lanez criminal case. There have been some documents filed here, and truly, I do not not truly, I'm sorry. I can't like think of the right words I'm trying to say when I'm like also reading y'all's stuff. Sorry about that. I can't honestly tell you that I have the documents in my possession because they're not public. So, I wasn't even I just took my rollers out, girl. I wasn't even going to do this update yet until or unless those documents came out. But I did see a couple folks on Twitter last night like we need somebody in new media to come on here and explain this. And so I'm going to explain as much of this as I possibly can. I'm going to explain what I do understand of it. And then hopefully, thank you to Tia. It's like, like when you just first take the rollers out, like you can't even like fully brush through it yet. You got to like let them sit there like that. Like it's like a staged process. Well, maybe, I don't know, maybe different hair types. Maybe y'all can brush straight through it. But mine, I got to like let it sit there before it like, it has a new identity. And then I can take the little pick and comb through it. But like I just took the rollers out like in the last 30 minutes while I was eating my Dave's hot chicken. So they just opened one of those by my house, and I've been eating it a lot. Okay, I need to stop, or else I'm going to turn into a Dave's hot chicken. Okay, but it's so good. Anyway, so what are we talking about? Tory Lanez. Okay, so I'm going to explain to the best of my ability what I believe to be going on. I'm not an expert in this field by any means. I have no insider information or anything like that. So I'm just going to be going off of what is publicly in the public record, and I'll do my best to explain the parts of it that I understand. Maybe together with all our minds together, may we understand. As you all know, because you're here to watch this video, this is a case of very high public interest. This is a case of high public importance. To be very clear, Tory Lanez has been convicted. He has been found to be guilty of a host of pew-pew related charges, including pew-pewing Megan Thee Stallion in the foot, having a pew-pew concealed in a car or something like that, all the things. He was convicted. Well, I started looking into this case a few months back. I guess it was like in the summer now at this point. And I noticed some irregularities. Okay. I noticed some irregularities. I noticed some things that appeared to not necessarily be constitutional. There was a lot of stuff. And if I get into trying to name all the things right now, I'm going to miss something real important. But the thing that really stands out the most to me has to do with what's called a Brady violation, or a Brady matter. And this is, if you remember, what's his name? Alec Baldwin. He was on trial for murder or homicide or whatever it was. And come to find out, like the bullet, there was like a pew-pew. It was loaded on the set of a movie. The pew-pew got pointed, aimed at a set worker, an assistant, or, something like that. And that person got pew-pewed and lost their life. So this actor goes on trial for it. Get your shit together. We're live, girl. So this actor happens to be Hailey Bieber, Justin Bieber's baby mama / wife's uncle. He gets put on trial for it. Now, I always get the lawyers mixed up. Was it Brian Steele or Alex Spiro? I think it was Alex Spiro. One of them two. One of them represented Alec Baldwin. And if you recall, that trial did start, but then like in the first week of trial, he got to walk out. He just got to walk out. Not only that, but he will never be able to be tried for it ever again. And why? Why was that? Do you remember? Do you remember why that was? I'll tell you. It's because of a Brady violation. Okay. It was Spirit. Thanks so much. Thanks so much, JZ MTV99. So he got to walk out the court, just walk out with his freedom. Thank you, Tia. It's Spiro, Alex Spiro. He got to walk out with his freedom. Now, why was that? Because of a Brady violation. What's a Brady violation? What is Brady anyway? You might be wondering. Well, and the reason that I show favoritism to this Brady thing is because I think it's the most important issue. I just do. But there's other important issues for sure. But I just want to focus on this one right now. So why did he get to walk out? Why did he get to walk out free? What's this Brady thing anyway? Well, a lot of times in American jurisprudence, what will happen is a new law gets set based on precedent or case law or stare decisis. Okay. I'm pouring myself a refreshment if you don't mind. Okay. I like blue glass right now. I don't know if y'all can tell that my little eye wash cup, I still haven't decided where to put it. So it's still just sitting on my desk. Anyway. So he walks out of court because of this Brady thing. So, you know what? You ever heard of a Miranda right? You know, like I'm gonna read. Did you get Mirandized? This like turned into a verb now. Like read you the Miranda right. Like what is a Miranda right? Well, it's named after this case, Miranda versus Arizona, or Arizona versus Miranda, or whatever. And that particular case stands for the proposition that you have the right to hear what your rights are. You have the right to know your rights. And so the cops, before certain stages of investigation, interrogation, and things like that, have to read your rights to some extent. You have the right to remain silent. Anything that you say to me beyond this point is going to be held against you, etc., etc. So in this case, we're talking about Brady. Okay, so it's another one of these situations that went all the way to the Supreme Court, and the Supreme Court had to set a precedent, the Brady versus Maryland precedent, and that one stands for the proposition, not that you have the right to have your rights read to you, no, but because you have the constitutional right to due process, a fair trial, and equal protection under the law. Any of the evidence that the prosecution has in its possession that might help you out, they have to tell you about it. Not only that, they have to give it to you. Oh my God. Faisal, I hope not. So in the Alec Baldwin case, what that ended up looking like was a box of ammunition. Okay. So why did he get to walk away? Why did he get to prance out of the courtroom? Why did Alex Spiro found what some people call a loophole. Some people call this a technicality. I don't think so. I think it's Alex Spiro found a constitutional right that was violated, and he's, for better or worse, he might be going to hell, but he's a really good lawyer. So he found it. He found the loophole, and what I don't think it's a loophole, because like the reason I like to call it a loophole is because it's a constitutional right. And now I'm about to sit here arguing that Tory Lanez should be able to get to use this constitutional right. So it ain't really a loophole. It's a law. It's a law. It's stare decisis. So in Alec Baldwin's case, what had happened, apparently, I mean, I wasn't there. This is just what was reported. But what had happened was there was a box of ammunition. And from this box of ammunition, there was one projectile, starts with a B, ends with an ullet. It was taken out of that box. That exact projectile was used to /unalive the little set assistant person who tragically, unfortunately, lost her life or their life. I don't know what the person's gender. Maybe it was a he, maybe it was her. I don't know. So yeah, he found it. He found it, Simply Fee. And look, listen, if I had Alex Spiro money and he didn't already hate me, I'd probably hire him too. But, I don't, and he does. So alas. But in that Alec Baldwin case, that box of bullets with the one bullet took out was stored in some locker down the street or something. It was down the street in a warehouse. I don't know, somewhere else. It was somewhere else. It was off over there or whatever. And that box of bullets was not turned over. Now, Alex Spiro brings that up in the first week of court. Why am I telling y'all this? Because this is how I'm going to try to explain to you how important and fundamental these Brady violations are in overturning a trial or mistrialing. So one thing too that I don't really emphasize that much is that at trial, Tory Lanez lawyers didn't pay that much attention to the Brady of it all. Alex Spiro was like Brady, 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 until the judge had to listen to it. Tory Lanez lawyer may have mentioned Brady in passing a time or two. I don't know if it was timely. I don't know if it was untimely. But from what I understand, and I'm not an expert here, but from what I understand, Brady is something that appeals courts and the Supreme Court can like still sua sponte on its own, because it's such an important thing. I think they can on their own do like look at that. Some things they can, some things they can't. I might be wrong about that, y'all. Please, I'm not an expert. This is just opinions right now, okay? But the judge in the Alec Baldwin case did, yes, rule in Alec Baldwin's favor and Alex Spiro's favor and say, yeah, no, the prosecution had to turn that box of bullets over. The box of bullets where the bullets of pew pew, the person who became unalive, this is a murmur trial. No, that's important evidence. It wasn't like, oh, the box of bullets had no fingerprints on it, had fingerprint. It was just not random, but it was just a box of bullets. Like no one was trying to argue in the case like, oh, it would have helped set him free. It would have helped prove he was innocent. It was just important evidence. It was just important evidence. Now, taking it a step further, the prosecution said, we didn't even have them bullets. We didn't even know about them. How are we going to be held responsible to turn something over to him that we didn't even have? Well, the judge ruled, and this is Supreme Court precedent, the judge ruled, I don't give a shit if you didn't have it. The cops had it, and y'all are working with them, ain't you? Somebody had filed something up under the wrong case number. I mean, it was a total accident from all appearances. Total accident. The whole case stopped. Halt, screeching halt. Not only that, he can never be tried for it again. They can't say, okay, now you can have the bullets. Now you can have the box. Let's go back to trial. No, that's called double jeopardy. Okay. Now imagine if it was like the murmur weapon and it had a gun and it had a fingerprint and there was no DNA and da-da-da-da-da. Like things become more important, but even just that, in that case, this is a murmur. They're on a live trial, homicide, whatever it was. Somebody lost their life. It's not like, oh, somebody could have lost their life. No, someone did. Someone's no longer around to talk to their family, to have more kids, to have kids. Like someone's gone forever off the face of this earth. And they were shot. The person who was holding the gun can never be tried again. Okay? That's the system we live in. And to some extent, when certain people are the defendants in trials, I'll be honest, I'm biased. Sometimes I'm like, that sucks. I wish that person would have been held accountable. I wish at least they would have gone through the trial. Other times, though, it's like, I want to argue. I want to use that. I want to say, wait a second. How does Alec Baldwin get to use Brady to walk clean out of court on a homicide or a, negligent, whatever it was? I don't even remember the actual charge, but someone lost their life. Negligent homicide, maybe manslaughter, something like that. And but Tory Lanez, there is a pew pew that they actually had fingerprint results on that never came up at trial. Not only that, the fingerprints were not Tory Lanez. You mean to tell me the jury sat in that courtroom and never heard the material exculpatory fact that they ran fingerprints and never found Tory Lanez fingerprints on that pew pew? That is the most important part of this trial insofar as trying to get it overturned, trying to get a mistrial, trying to get whatever to me. Now, I want to be very clear. Just because Tory Lanez fingerprints weren't on the pew pew doesn't mean he didn't pull the trigger. Doesn't mean he didn't shoot somebody here, there, and everywhere. And I want to be very clear, just to reiterate, legally speaking, Tory Lanez has been found guilty. So I don't know nobody over here suing me. No, not me, not it. Go somewhere else. I'm not saying he didn't do it. What I am saying is I don't believe, in my opinion, based on my understanding, that he received a fair trial. Specifically under the Brady versus Maryland, precedent. I don't think he got a fair trial because his lawyer didn't have the opportunity to meaningfully argue and tell the jury and inform the jury, my client's fingerprints were not on this pew pew. So a lot of other stuff, y'all, in the case, like just to be very clear, like I focus on that because I really don't see anybody else really focusing on it, like driving it home. Like a lot of people are like, well, the gunpowder residue and the this and the that. A lot of that stuff, though, the jury actually did hear. There was some stuff that feels more like Brady. There's another issue that kind of feels Brady-esque in that Brady-esque, kind of in this Brady universe. And like we already have the one Brady issue with the fingerprints, right? The other issue that kind of feels Brady-esque is that they what was the other thing that they had done? I lost my train of thought because I got caught up thinking about the gunshot residue tests. Like, there's only 3 people could have pulled the trigger. The driver, his name's Jaquan, Tory Lanez, who got convicted, and Kelsey Harris, who was in the car. Megan Thee Stallion could not have pulled the trigger on her own self from all the way back there. So, she's ruled out. So the only people whose hands got tested for gunshot residue were, I think, Kelsey and Tory Lanez. So they didn't test anybody else's hands for the gunshot residue. Kelsey's hands got tested for the gunshot residue, and she had gunshot residue on her hands. So they didn't run Kelsey's DNA against the gun, which I found to be odd because apparently, and I didn't know this until looking into the Tory Lanez case, once you run DNA test on something, you can't do it again. It's like you have to soak it in this solution and wipe it down with this stuff that basically takes all the DNA off of it. So they didn't really find Tory Lanez's DNA conclusively on that gun. They found portions of DNA that could have possibly lined up with his, but like there wasn't anything conclusive. There was no possible way at all whatsoever that his DNA could have been was found on the magazine. They ran his DNA in the magazine. They did not run Kelsey Harris's, even though she had gunshot residue on her hands. We could keep going. There's a lot of weird. There's also a lot of weird, stuff going on. Yeah, exactly. People like I know there's a lot of stuff going on. There's a lot of people in here who have been following this case for a long time. I know y'all know all the details. The 911 call, I feel like is also Brady. I think, from what I understand, Tory Lanez's defense team was never allowed the Brady call. Am I misunderstanding this? Megan apparently, allegedly, has not been given consistent statements when she tells her stories. She'll say, she did not have a relationship with Tory Lanez in an sexual way, but then she later came out and said, yes, she did. At first, she said she wasn't even shot. She said she had stepped on glass. Or something else. And it's like, were you shot? No, I wasn't shot or whatever. And then, her story ended up changing and stuff like that. So all that, is really neither here nor there at this exact moment because he has been convicted. However, Tory Lanez is really fighting. Another thing too, I want to just point out and mark it for like, the history books and all. The call is sealed. No one has heard it. Okay. I think this is a Brady violation. And I do wonder why Tory's lawyers haven't argued like more aggressively on like the Brady issues. Like, why have we not been able to see the 911 call, hear the 911 call? Maybe they did. Maybe I'm missing it. So anyway, listen. So Tory Lanez, he appealed. He appealed the case. He appealed the conviction, and the appeals court of California. This is the second district. Is it district or circuit? It's district. Second district court of California. He has appealed, and as of November 12th or so, he his guilty verdict was affirmed at the first appeal level. Now, we'll get into like what has to happen there, but let's just say, that he runs out of options at this level. Then the next thing he would, I guess, do is appeal to the state Supreme Court, which is in California. And then after that, if it doesn't go his way, I think he can go all the way up to the United States Supreme Court because this is a federal question. Again, I'm not an expert. I am not an expert in appellate practice. I do not know what I'm talking about. This is just what I think. I think this is what I remember being the case, but like y'all are more than welcome to go and, consult a real expert. So yeah, that's another. Yes. Thank you. Oh my God. Day one's only no new friends. Day one's only no new friends. Yes, exactly. They didn't even run the pew pew for ownership. This is another thing that I think is kind of like Brady-esque. It's like, at first it was kind of like told and said they couldn't figure out who owned the gun, like who it was for. But then later on, come to find out they didn't even try. They didn't even try to run the gun. They didn't even try to run the registration of the gun to see who possibly see who owned it. And that seems very odd. If there's a pew pew used and you're going to charge somebody with possession of a pew pew, don't you think the cops would run the weapon serial number to see who the pew pew belongs to? Somebody's going to get in trouble for having a pew pew in a car, which fine. If that's a law, that's a law. Y'all didn't run the numbers to see who owns it. It's almost like you had your victim, your defendant in mind before it ever went to trial. That's what it feels like to me. Now, again, y'all, he was convicted, but I don't feel like, it's my personal opinion, he didn't get a fair trial. That's my opinion. I'm allowed to have an opinion. Okay. I'm allowed to disagree with a jury, while also saying the jury saw more than me. The jury saw this happening in real time. This is why we have juries. This is why juries get to decide things and not me. I'm not the decider. I don't get to decide nothing. Like, I'm just a girl over here in Princeton on the other side of the country. Okay. So I'm not really, don't listen to me. Don't listen to me for facts. All right. This is just my understanding. Okay. So Tory Lanez docket has been a little poppin' lately. And I'm going to pull up the case docket sheet. What is this? Like from the website? Okay. This is a great point. Day one's only no new friend said, then during Milagro case, right. So there was another case that just was in the civil court recently, and it just ended. Was it this week? Did we get the verdict this week for that, or was it last week? Just ended in the last week or so, and that was Meg the Stallion, the victim of the shooting. She did sue a blogger, a YouTuber, a radio personality for defamation and some other stuff. But in that case, some more information came out because Meg the Stallion had to take the stand and testify. And so in the testimony of the case, was it Meg that said it? Actually, I don't want to get sued for defamation, and I don't 100% remember if it was Meg or someone else who said it. So let me amend before I say it. Someone said at trial, I think I remember it being Megan, but maybe it wasn't. And maybe it wasn't. Maybe it was Travis Ferris. Maybe it was somebody else. But at this recent trial, somebody was on the stand and we're saying about the Tory Lanez case. And like day one's only no new friend said, then during the Milagro case, we found out LA, the prosecutor, didn't want to pick up the case, but Meg's people pushed for the case. Everyone said LA picked it up. Meg didn't pursue it, but that was a lie. Okay. So apparently, like what had came out at the Milagro trial, apparently Meg's people kind of pushed for Tory to be prosecuted. Like LA prosecutors were just kind of like, she said she wasn't even shot, like moving on. But no. Meg's people, apparently, maybe it was Desiree Perez or them, pushed for this case to go through, and now he's in jail. And another thing too that I just want to say, just generally, that one of the reasons why I'm covering this case is like, covering this case and the Milagro case has been very discouraging because it feels like justice is not really being done. It feels like people are being picked on, and it feels like stuff's not really fair. Again, I wasn't in the Milagro trial. I was not there for not a single moment of testimony. I wasn't there. I don't know exactly what all the jury heard and all of that. But okay. Sorry, I was reading some comments. But I kind of think like Milagro, yeah, like she definitely had some wins and all that. Like she got, declared to be media and all, and she doesn't have to pay $30 million. She only was made to pay $59,000. But y'all, I mean, that has to have been a very traumatic incident that just happened to her over the last couple of years of after getting sued and then going to the trial and then all of that. And it's like she has to pay still 59,000 plus whatever the attorney's fees end up being. She did get acquitted or whatever, like not liable on the defamation because I mean, there was some stuff Meg did wrong. There were some wins, and I want to celebrate that for her. Truly, it could be way worse and all that, but like, I still don't really think is that fair what happened. Like, other than maybe that AI corn thing, which that's a new law. I don't really know much about it. The other stuff she said and was dragged into court over and had to endure this lawfare for years or at least a year has been stuff that I think is just free speech. Like she said, I could go through a list of all the she lied about. I don't feel like that's defamation. Like, again, she didn't get found liable of defamation because she's a media defendant, so she's not liable for defamation. But like, even just the fact she had to defend herself from it, like, I just don't feel like that's fair. I don't feel like that's right or fair, whether she was found to be media or not, whether she's just a lady on the internet, a radio personality, or the Queen of France. I mean, why can't you say you can go through a list of things people lie about? I don't. That's another issue. She wasn't even the only person saying it. So it's like, what? We're just playing like duck, duck, goose on who gets to have an opinion or not. And if you're not, if you're it this time. Like, you have to be the one that has to be fighting for your life in court over nothing. Anyway, sorry, I'm reading y'all's comments, but the reason I minimized the docket sheet is there's one thing that I wanted to say and I still haven't gotten to it, but covering this case has been kind of discouraging because I feel like stuff's not really fair. I don't really feel like, look, if Tory Lanez would have got a fair trial, just like Diddy, I feel like Diddy got a fair trial. I feel like Diddy got a fair trial. He had those bulldog lawyers that were fighting for their life as if Diddy's life, as if it was theirs. You know what I mean? They were fighting for Diddy's life as if their life was on the line. That's how it looked like to me. They were willing to lie, cheat, steal, kill, and destroy to win for Diddy. All right. So for that reason, I feel like he definitely got a fair shake at a trial. And you know what? They said your behind needs to be in jail 4 or 5 years, and that's what has to happen. Y'all haven't heard me saying free Diddy. Y'all have not heard me saying free Diddy because every single nook and cranny of possible get out of jail card that Diddy could have played, he played it. So that's his lick to take. All right. But the Tory Lanez thing, I'm like, if he would have got a fair trial, y'all wouldn't hear me sitting here, going on about this for months. You wouldn't. I'd be like, well, I mean, it sucks. I definitely see how I could have maybe come up with a different opinion myself. No, the jury didn't even have all the information they needed to make their decision. I don't feel like they did. So that's, it's like that doesn't feel fair to me. That's my opinion. However, that being said, the jury disagreed, and again, I don't know if the jury would have disagreed. If the jury would have heard the sentence from Tory Lanez's lawyer, my client's fingerprints were not on that gun, but other people's were. My client's DNA wasn't on that magazine, but other people's were. If they would have heard all that together, would they have made the same decision? Perhaps not. Perhaps so. I mean, none of us know. None of us know. So on November 12th, Tory Lanez's appeal was decided, affirmed. He was, the ruling conviction stood. And there was this 46-page long opinion, and I was going to read it, but I don't know if I'm going to read it or not today. But there's this 46-page opinion. Basically, it's the appeals court saying, no, we agree with the lower court. Like, that can stand. The jury had enough information to find him guilty, the end. And I'm like, I don't really think they did at all, but okay. And again, like I said at the beginning of the video, there is options and opportunities for Tory to continue appealing this. And I have reason to believe that the federal government does have their eye on the case. So once it gets out of state court and goes up to the United States Supreme Court, then maybe things will be different. But then again, y'all, I mean, one of the justices, I think her name's, was it Katanjali? What's her name? Katanjali Jackson? Katanjali. Is that her name? Anyway, she's on the Supreme Court. She went to a Cowboy Carter concert or something. So I mean, who knows? Who knows? Maybe everybody's just going to be deciding against Tory Lanez. But the thing I wanted to say is, despite how frustrating and kind of disheartening the coverage of this case has been, on November 12th, I saw that the appeals court had affirmed the ruling, affirmed the conviction. I'm like, this just doesn't feel fair. Like, I feel like they need to at least do a new trial and have the Brady stuff enter in so the jury could know about the DNA and the jury could know about the fingerprints not being there and like that there was fingerprints ran at all and all that. Because again, y'all, I'm just thinking back to that Alec Baldwin case. And I don't know what state that was in. Was that in California? I mean, it would be even more egregious if that was also in California. But even though it's like, a little disheartening that these decisions are coming out in ways that I don't think are correct and I don't think are right and I don't think are fair, it's also like making me feel like I still do need to just still cover it and stay the course, even though it feels rigged, even though it feels set up, even though it feels unjust, even though it doesn't feel fair at all. And it's like discouraging. I mean, I definitely have seen a lot of people like, man, I don't even want to follow this case anymore because everybody just knows exactly how it's going to turn out anyway. And it's like, maybe so. If it turns out that way, then will I be surprised? No. But Tory Lanez was viciously, violently, almost nearly like fatally attacked in prison, awaiting these appeals, awaiting these arguments to be made. He was stabbed some whole bunch of times, had to be rushed to the hospital. I think both his lungs collapsed. Like he could have lost his life in prison, awaiting these appeals. And it feels kind of life or death to me. And it definitely feels like the highest of the high powers that be of this devil matrix are kind of like, able to get what they want out of this situation. So it's like with my little baby platform and with my little tiny voice for whoever's listening, all, 514 people or whatever, I feel like I'm just gonna, I'm gonna let it shine, let it shine, let it shine. I'm gonna say what needs to be said in my opinion, because as of December 4th, Thursday, December 4th, 3:28 p.m. Eastern time, we still have the freedom of speech. We still have the First Amendment over here, and I still get to say what my opinion is. So, all right. So, girl, it's Tory fought. I think you meant to say fault. Before you come over here, before you, girl, ma'am, before you come over here saying that an innocent, possibly innocent black man deserves to have his rights violated, please learn the difference between fought and fault. Be dismissed. Anyway, so here's the docket sheet. Here's the docket sheet. So this is the appeal. As you can see, September 2023, we're going to scroll all the way down to the most recent filings, and these are not available to the public. So all I can see are these entries. So here's the opinion. This is the keeping the ruling. We affirm. This was on November 12th, 2025, last month. And then on the 1st, so 3 days ago, Crystal Morgan, who is on the thumbnail image of this video, also is Tory Lanez's lawyer, current lawyer for the appeal. She used to work for the United, what's it called? Not United Justice Coalition. Unite the People. Unite the People. Caesar McDowell, whatever his name is. She used to work over there. She don't work with them or for them anymore. And from what I understand, they are no longer involved in the Tory Lanez case at all. So that's her right there. And she filed a notice of change of address for herself on December 1st. And then on December 1st, she also filed a rehearing petition. So this is appellant's, that's Tory Lanez, petition for a rehearing. So we're going to have another hearing, another, I guess, like oral argument of sorts. And then the very next day, so this was 2 days ago, December 2nd, filed request to publish opinion. So these are two separate things, two separate issues, two separate goings on. Okay. The first one right here is the rehearing petition. And the second one is a request or a petition to publish the appeals court affirmation, their opinion. So we'll take these in turn and kind of explore a little bit as to what I understand this stuff means. So the first one will go first. Filed on December 1st, rehearing petition, applicant's petition for rehearing. So let me just get my correct. Let me get my correct thing up over here. Okay. So this is a public website from the california.gov courts.california.gov website. This is selfhelp.courts.ca.gov. Step 7, petition for rehearing. Any party, whether appellant or respondent, can challenge the Court of Appeals decision. Okay. So challenge the decision. They're essentially, Tory Lanez and his lawyer are challenging the decision by filing this petition for a rehearing. This petition asks the Court of Appeal to reconsider the case and correct any mistakes in its opinion. Generally, the court will agree to a rehearing only if the mistake is a major error of fact or law, or if an important argument was not considered in the court's decision. Okay, well, I don't know. Was Brady considered in the court's decision? I don't think so. Hopefully somebody comes through with a Brady appeal or a Brady decision at some point. I mean, I just feel like Brady wasn't properly briefed out, but I'm not an appeals lawyer. Okay. Crystal Morgan looks like to be a superstar, a rock star. She's the one arguing in appeals court, not me. I don't mean any disrespect in any way. I'm like a girl from the internet, truly. I went to law school and then I never practiced in a trial ever. So I don't mean to come on here and act like I know anything more than anybody. I'm truly not an expert. But I just saw how easy it was for Alec Baldwin to just walk out the front door of that court. And it's like, then why can't I've seen what Alex Spiro can do for Alec Baldwin? What can he do for Tory Lanez? You know what I mean? Obviously Alex Spiro is opposed to Tory Lanez. I think he actually legitimately, literally represented Meg Thee Stallion against Tory Lanez himself. I don't know if I got that right, but this is what Tory Lanez is asking for. A petition for this court to reconsider what Tory Lanez is trying to say is their erroneous decision, but also possibly reflect upon an important argument that was not considered in the court's original decision. Now, we do not have the public. I mean, when I say we, I mean the public. We don't have access to the filings, so I don't know what grounds Crystal Morgan is arguing for a rehearing. I don't know exactly, right? Because it says here, Alex isn't Megan's lawyer. So Alex Spiro didn't represent Megan Thee Stallion at any point. That's true. Let me see. Let me look it up. Is Alex Spiro Meg Thee Stallion's lawyer? Okay, well, according to BusinessInsider.com, yes, he is, girl. Yes, he is, because according to BusinessInsider.com, don't take it from me, though. Look at Business Insider. The title of this article, this is from December 3rd, 2025. This is from yesterday. This article from yesterday. Celebrity lawyer Alex Spiro will represent a co-star competitor in the legal fight of its life. Real estate data company, da-da-da. Okay, according to court filings on Wednesday, Alex Spiro will now defend Crexy in its legal battle with the real estate data giant. The $3,000 an hour lawyer has represented clients like Elon Musk, Jay-Z, and what's that say right there? Let's read it together. We're doing Hooked on Phonics. Megan Thee Stallion. And has also worked for a variety of businesses. Okay, so he is her lawyer. Now, what exactly he represented her in, I mean, girl, your guess is as good as mine, but don't sound like you really know what you're talking about either. So I didn't say he was her lawyer versus Milagro. Y'all gotta pay attention to what I say. That's how people end up getting sued and then lose. Suing people and then losing. I didn't say he represented her in the Milagro case. I didn't say he represented her in that case. And I didn't say he went to court with her. What I said is I think he represented her in the case against Tory Lanez, but in the criminal case that Tory Lanez. But now I'm going to actually look it up because I don't want Alex Spiro coming over here saying I'm lying about something. So let me just make sure I do a formal retraction mid live stream. Let me just do Alex Spiro, Tory Lanez. Okay, this is from May. Okay, here we go. All right, look. Don't ever say I didn't fact check nothing. Okay, don't ever say it. Here we are on Billboard.com. Megan Thee Stallion's attorney shuts down Tory Lanez defense claims of new evidence. Okay. Girl, they did her dirty. Oh, they did her dirty. Okay. What's the first sentence right here say? Everybody together. 1, 2, 3, go. Megan Thee Stallion's attorney, Alex Spiro, has replied to claims from Tory Lanez. Okay, so I think that settles that, right? Can we all agree? Okay. Just saying. I'm not trying to get sued by Alex Spiro. Okay. So if anybody has anything else to say, just let me know because I will lie. I have no problem live fact checking. No problem at all whatsoever. And the jury will have to hear and listen to that part too. Can't play fast and loose with the facts. Okay. Shout out to the Life of Samad. Shout out to you. Thank you for the £1.99 super chat. Hey cousin, how y'all doing? How are the UK cousins holding over there? Anyway, okay, so back to what I was saying. Where were we? Nope. Here. So in this particular case, I couldn't tell you what exactly Crystal Morgan is arguing. Is she arguing this petition for rehearing on account of wanting the court to reconsider the case and correct any mistakes? Or is she saying there was an important argument not considered already previously that needs to now be considered? If there's an important argument that the court did not consider that now needs to be reconsidered, I think there is still a lot of uphill battle on why that wasn't considered first. Like, did it ever get brought up? You can't just bring something up for the first time ever on appeal. From what I understand, it has to be newly discovered evidence. It has to be stuff like that. I could probably dig into that 42-page opinion and try and speculate and throw darts at a dartboard in a dark room in a warehouse. But that's literally what it would be like doing. I don't know why she filed this. I mean, I know why, because she wants to challenge the court. She wants to challenge the affirmation, the affirming of the thing. And again, y'all, even if this court right here, there's a lot more avenues for appeal. Even if this doesn't work, there's other stuff. There's other higher courts, plural. There's 2 more courts from what I understand, the state Supreme Court. And then if the state Supreme Court affirms, then it can go up to the federal, Supreme Court. I might have that wrong and backwards. I'm not an expert. I don't know. But any party where they go. Okay. So that's the first thing. That is the first thing that seems to be going on, is that Tory Lanez wants the judges to challenging at this level first. Challenging at this level. We want a rehearing. Now, what's this other thing he filed? Or Crystal Morgan filed on the behalf of Tory Lanez is a request for publication of opinion. A request for publication of opinion. This is a totally separate thing. Something totally separate. Request to publish opinion. Now, this publish is one of those funny legal words that has its own meaning. It doesn't just mean put it on the website. It doesn't just mean is it available to the public. It means publish, almost like capital P publish, to put it out on the official record to make it citable, to be able to cite it as precedent. So currently the case is not citable as precedent. It's an unpublished opinion. And I did have somebody on Twitter that was like, I hope you're going to point out in your live today how messed up it is that this was ever cited as an unpublished opinion in the first place. This should have obviously always been a published, citable, precedent-setting opinion, um, was the kind of like implication. And I don't actually know if that's true or not. So I did do a little bit of research before I came on live today. And I want to run through some of that research with y'all to let you know what I found and things like that. So first, let's start here. Hold on, let me get my little notes. Hold on, I'm trying to find the right thing here. Okay, hold on. Okay. So here's another public, Meg said, I cannot understand why Brady wasn't brought up in the appeal either. I always understood Brady violation to be a slam dunk for defense and appeal. Me too. Me too. Thank you, Life of Samad. Alex Spiro apparently was the first one to let Milagro know via email that she's getting sued. Oh, wait, by Milagro or by Megan? The Stallion. Thanks so much, Kels on Earth, for the 149 super sticker. Just for the record, Brady violations were brought up. The response did not include a reason why they affirmed the decision without covering the Brady violations. So maybe, okay, shout out to you, Bat Dad. And I think Bat Dad was the one on Twitter who was like, can you also point out how it's messed up that they didn't do how they didn't do it as a published decision at first. So that's what we're about to get into. But let's back it up a little bit to what we were just talking about. They did bring up the Brady violations. Okay, so let me pull up then the decision, the order from the appeal level. Okay. What page, do you know what page they bring up Brady on? Okay. So I have it right here. Here's the order. See how it says this at the top? Not to be published in the official reports. So if it's published in the official reports, it becomes binding precedent. It becomes something that is in the case law. It's basically a law at that point. So this is not, don't publish this. So if you do like a control F on here and you type in Brady, see how it says no results found? Up here, see how I typed in Brady? No results found. Let me try to type in finger. DNA testing revealed a profile of at least 4 people. DNA testing. Peterson was not one of them. No usable fingerprints were found on the gun. I thought fingerprints were found on the gun, but not his. Or whoa, hold on. I'm feeling like I'm getting different stories from different places too. Like I just want to see the fingerprint report myself at this point. But as you could see here, I was unable to find anything about Brady. Like if you type in Brady, let me just type in Maryland. No, nothing. So let me pull up. Do I have the... Is this the motion for a new trial? No, this is 2023. I don't think they argued Brady there, did they? The motion for a new trial? No. That's the thing too. The motion for a new trial should have included Brady. So I don't know if they maybe just like didn't bring it up. I don't, if you had citations, that'll be helpful. Thank you so much to Bernice for the $10 super chat. Can Meg asking a cop if she's going to jail and then added she have an image to protect, or when police cam shows her getting out of the truck, stepping on the bottle, walking back, bleeding, the cop tells the cops like, What's the question? Can that be used against her? If it could have, I think it already would have been. Thanks so much for the $10 super chat. Simply Feast said that's one of their misstatements regarding the fingerprints. Crystal Morgan did argue it at the oral argument hearing. Okay. Pretrial hearing, opening statements. Okay, so these are transcripts. Transcript of Kelsey Harris testimony, motion for new trial. I don't think I have the transcript of the oral arguments. Do I? Did anybody send me those? Okay. So again, those videos from Free the People, if I can recall correctly, it was 2 mil. Crystal Morgan. So maybe she argued it. Okay, so maybe, again, this is just like throwing darts at a dartboard in a dark warehouse at night with a blindfold. I mean, I really don't know because I don't have the document, but maybe this motion for rehearing has something to do with Brady. Like, hello, you didn't even address the Brady that I brought up. Something like that, maybe. As of right now, December 3rd, I don't know. Okay. So the next issue, other than the motion for the rehearing, is Crystal Morgan has filed a petition to publish, to make this opinion published. Now, I did do a little bit of research on this issue. Where is it? Right here. This is the page I wanted to show y'all. And this is another public, open to the public, available to the public website, the courts.california.gov, Judicial Branch of California, unpublished and non-citable opinions. Okay. Unpublished or non-citable opinions are opinions that are not certified for publication in the official records and generally may not be cited or relied on by other courts or parties in other actions. Unpublished opinions are available as follows. Okay. So where is the thing that shows like... I'm just going to pull this thing up because I'd like taken a screenshot of this web page. I'm just going to use the screenshot because I cannot find that web page. I have a link to something, but it ain't this. So this is from like one of those like california.gov like websites. Unpublished opinions are not citable in cases or action. What is an unpublished opinion? The majority of Court of Appeal opinions are not certified for publication and thus are not published in the official reports. These opinions are known as, quote, unpublished, but it's not like they're sealed or something. Like we can see them. Like I just showed y'all, we could see the opinion. It's just not, you're not supposed to use it as like precedent in the case, in another case or whatever. The majority of the Court of Appeal, okay, these opinions are known as unpublished. They generally cannot be cited or relied upon in other cases. This does not mean, however, that the contents of opinions are protected or private. All opinions posted on this site are public records and may be indexed by internet search engines. Okay, so I did look up how often does the California Court of Appeals make its criminal cases, because this is a criminal case, how often are the criminal cases published? And come to find out, it's only about 3%. Only about 3% of the time are criminal case opinions published at all, like on either on first instance or not. So I ask, can the court have like made an opinion? Like, because I'm asking, like what my research question was, can the court just on its own publish an opinion, or does someone have to request? Because that's kind of was like, I like to always start off like looking at both sides, because I do think the courts are biased and stuff, but this is a new court. Plus, appeals courts have three. There's a panel. So it's like harder for like three whole people to like agree to be corrupt than just paying off one judge. Okay. So just in general, I have like, I like to give like the benefit of the doubt for the whole thing until I just can't no more. So like, what if judges just can't make something public until or unless somebody requests for it to be published? Well, turns out that's not the case. They could have, if they wanted to, the appeals court could have chosen to publish this opinion as a citable published opinion, but they chose not to do that. That being said, that seems to be the ordinary course of business, as in 97 out of every 100 times, that is what they do in criminal cases. Again, 97 out of every 100 times, that is what they do. So in this particular case, I do not think that they were necessarily like picking on Tory Lanez. However, I did go and look like in what cases they are supposed to have opinions published or citable. And I'll show y'all what I found, and I'll let y'all make your own mind up about it. So let me pull the screen up. Okay. So this is the website. I knew it was BS, T what Tia said. I'm like, yeah, y'all tell me your opinions. It was BS. Simply Fee said, AKA they're just not comfortable with their opinions. I mean, it's hard. It's hard to make all these seemingly arbitrary opinions reconcile with each other. And you have a client like Tory Lanez, you have a client with money, they're going to keep appealing, and these judges are going to have to make stuff reconcile. So this is the rule under which this whole thing operates. So a court of appeal can order an opinion published on its own initiative, which they did not do in this case. Under Rule 8.1105C and 8.1105E1, courts should do this. So again, this is when courts are supposed to make an opinion published and citable when one of the following: it establishes a new rule of law, it applies to an existing rule, it applies an existing rule to a new set of facts, which I do think that necessarily did happen in this case. Resolves a conflict in the law. I don't think that happened here. Involves a legal issue of continuing public interest. Yes, obviously, the public is interested in Tory Lanez. Look, there's 561 people in here right now listening to me talk about statute 8.1, rule 8.1105C and 8.1105E1. So obviously, the public is interested. Otherwise, y'all wouldn't be in here just for fun. Makes a significant contribution to legal literature. I don't think this opinion makes very many substantial contributions. I think we can all agree. Criticizes or clarifies existing law or addresses errors in a lower court likely to recur. So let's read the actual statute here, 8.1120, requesting publication of unpublished opinions. A, request. Number 1, any person may request that an unpublished opinion be ordered published. So in this case, Crystal Morgan requested it. The request must be made by a letter to the court that rendered the opinion, concisely stating the person's interest and the reason why the opinion meets a standard for publication. So if the court itself didn't make it public, then there's another way we could do it. A person, anybody, you or me, could say, no, this should be public. Why? Well, because it involves a legal issue of continuing public interest. Or in some cases, for example, because it addresses errors in a lower court, et cetera, et cetera. So if the judge didn't do that, if the appeals court didn't do that in a given case, then a member of the public can do so, or a lawyer in the case, or the plaintiff, or the appellee or the appellant or whatever in the case can request it. So when can the person do so? Well, in some situations, why and how do they have to do it? They have to state in their letter their interest. So Crystal Morgan is the one in this particular case who filed it. So I'm assuming she said, I'm the lawyer on the case. And the reason why the opinion meets a standard of publication. So, and this is a matter of public interest, or this sets a new precedent of law, or this resolves an existing conflict of law, or something like that. I don't know what she said because I didn't read the thing she filed. It's not public as of yet. The request has to be delivered within 20 days of the opinion being filed. So the opinion was filed November 12th. Today is December 4th. Let me pull up my calendar and see how many calendar days ago that was with the weekdays. Okay, so the 12th. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. I don't know if Thanksgiving counts, so I'll just go 11, 12, 13, 14. So today would be the 15th day. Okay, so it was filed 2 days ago, so I think she made it. Now is that court days? Is that day days? I think these are all court days. The rendering court must also send a copy of its recommendation and reasons to all parties and any person who requested the publication. Okay. So if the appeals court doesn't make this into a published citable opinion, then it becomes an issue of appeal itself, which the Supreme Court of the state can then determine. That's where you get C, action by the Supreme Court. The Supreme Court may order the opinion published, or they can deny it from being published. The court must send notice of its action to the rendering court, which would be the lower level appeal court, all parties and any person. Then you have Section D. A Supreme Court order to publish is not. Okay, this is very important. A Supreme Court order to publish. So if the Supreme Court were to say, yeah, no, you have to make this a citable opinion because it's a matter of public concern, or because it clarifies an existing conflict of law, et cetera, whatever the reason is, which again, we don't know because we don't have the document, but it's one of those few things. If the Supreme Court says, yeah, no, you have to make this a citable opinion, that's not the Supreme Court saying we agree that it's a correct decision. It could still be appealed and go up to the Supreme Court of the state. This is all the state Supreme Court. It could still be appealed and go up to the Supreme Court of the state. And in that case, that's not the Supreme Court of the state saying, oh, yeah, we think that's a correct decision. That's just them saying, you can make the decision public. And then, if it comes up to us for appeal, we'll decide on it there. But it's not the same thing as them deciding on an appeal itself. Does that make sense? Hopefully so, because that's the only way I know how to explain it. So let me pull my notes here. Again, it does appear on the text, on the face of the requirements, that the appeals court should have made this a citable, published opinion in the official records. That's what it appears to me. But they didn't. I do think, Tory Lanez gets picked on in the judicial system. That's my opinion. I'm allowed to think that in my opinion. I do think that he did not get a fair trial, in my opinion. It has nothing to do with anything anybody said on the stand. That has nothing to do with anything that anybody said not on the stand. That has nothing to do with anything anybody said on Gayle King. The reason I think he didn't get a fair trial has to do with the fingerprints and stuff like that not being shown to the jury. So maybe my understanding of the whole thing is incorrect. Again, maybe I'm just stupid. There's always a possibility. I don't know nothing. However, only 3% of the appeals court cases that they make an opinion and a ruling on ever do get published at all. And that's either with the judge asking, the judge doing it sua sponte on their own initiation, or with somebody requesting it. So only 3% of all criminal cases in this particular district court, the circuit court, or whatever, this district court, the second, there's a district. I always get district and circuit mixed up. But this appeals court, that Tory Lanez case was heard in, only 3% of the cases ever are citable. So it does seem more run-of-the-mill, more ordinary for them not to cite the cases as citable or publishable than to make them publishable. But I could see why people would believe that the reason is because they don't really want to stand behind their opinions because they know they're BS. I mean, if y'all want to believe that, I could see why you believe that. I'll put it that way. So there was something else I wanted to talk to y'all about. Okay. And it kind of relates to this. It is it's we're in another state now, but it has to do with like the Milagro stuff. So you know how like in her case, one of the things that she was actually found liable for was that deep fake AI altered SUL depiction of a person, blah 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 thing, the deep fake AI corn, this, that, the other. Um, oh, you went and listened again. Okay. Bat Dad said I went and listened again. She went with People versus Merriman, not Brady. What's People versus Merriman? Let me refresh my recollection. Is it part of the Brady progeny? Yeah, this has nothing to do with Brady. And it's a homicide. Yeah, subject to revision before publication. Yeah, this is a 2023 case? Merriman. Yeah, this is about questioning about a prior allegation of misconduct, prior bad acts. This is an evidentiary thing with prior bad acts. Okay, so I don't know why she didn't bring up Brady. She did address Brady, Tia said. Do I have the transcript? Does anyone have the transcript of the oral? Meg said, I didn't think they argued about Brady because I remember us talking about them not using it. Yeah, like not bringing it up. And I don't know if you don't use it, you lose it type of thing. Like some things are not, and some things are like you knew about this and you never brought it up. So like too bad you snooze, you lose. Too bad, so sad. And that's kind of how I feel about like the Milagro case. Like I think she could have won it on anti-slap, and Meg the Stallion could have had to pay her attorney fees. But that all has to happen before a jury gets involved. And if you don't make it happen before a jury gets involved, I think you give up your opportunity to argue it. Like, I got sued in California for, I mean, it was a restraining order, but it ended up turning into like a whole entire several tens of $1,000 court case. And I filed an anti-slap motion. And before it ever reached any type of trial or anything, it got dismissed. And that lady owes me my lawyer's attorney's fees, like close to $100,000 because of it. So, if I wouldn't have argued that at first instance, I think, at some point you kind of give up your right to argue that. And then you've kind of like stuck with your strategy and you have to go with that. You can't say, oh, I wish I would have did it different and then change it. So I don't know if Brady is one of those situations. I think that it's one of the ones that like, because it has to do with a fair trial, you always have to be able to bring it up. But I mean, I really don't know. I'm making stuff up, honestly. Okay. So let me switch gears for a second because I want to talk about this deep fake AI corn. Okay. So just now we were in California. Let's go over here to Florida real quick. Because in the Milagro trial, Megan Thee Stallion versus Milagro, Milagro was sued and held liable for this deep fake AI corn thing, right? That was civil. That was not criminal. Okay. And all the things that she did were before this new thing came into effect. So I just wanted to bring this to y'all's attention because it is my strong belief and opinion that a lot of these deep fake corn things are created to set traps, to bait certain people into doing certain things, whether it be saving it on your hard drive, sharing it on your Instagram, whatever the case may be. I believe this has happened to me before. Someone created a fake pornographic image, video, a deep fake. They put somebody's face on somebody's body and sent it to me in an attempt, I believe, to get me to share it, thinking that I'm the type of lunatic that would share that and promote and put out a link or something. Like this came to my email. This wasn't like a public on Twitter thing. But it was public. It was a public video because it was like on a website. Anybody could just click on it. But I think, I'm not going to necessarily name any specific cases, but I think there are other cases where people have been set up to try to make them, to try to lure them. It's kind of like when Jesus is walking through the desert or whatever for 40 days, and like literally Satan comes tempt him with like a dinner, like a steak or whatever it was. I don't know. I haven't read the Bible in a while, but like it's just too good. It's just too tempting. You're starving, and they have this thing right here. You're up, and she's in this super compromising position. Girl, my internet just flickered. I understand that. And I am not saying Milagro. I said I'm not saying any specific. I'm not saying any specific names. I never said Milagro shared this link. It is my impression and understanding she did not share the link. It is my impression and understanding she heart reacted on Twitter and told people if they just simply had to see it, go to her likes. But I am not in any way saying she shared the link. I'm saying I also would never share a link. But this situation that happened to me is not exactly the same as the situation that happened to Milagro, and the way that she handled it and the way that I handled it are not the same. That being said, I'm not even talking about Milagro. I'm saying in general, but let's zoom out. Let's zoom back. I'm saying in general. I don't think every deep fake is out there just for fun. I think some of it is out there to trap and entrap. Now, in the Milagro case situation, she was sued for saying, go to my likes. And she had liked, the deep fake AI pornographic video, allegedly of Megan Thee Stallion. I never saw that video. I never looked for it. I don't want to see it. From what I understand, it's not even up online anymore. Thankfully, videos like that shouldn't be out there. I do think that is grotesque. Like, I just want to be very clear. Like, I can have my opinions about people and still have my opinions that, like, we shouldn't be making fake AI porn. Like, I'm not sharing any of that. I'm not saying Milagro did either. Actually seemed like she had the same intuition as me. Like, I ain't sharing that. I ain't sharing that. But then, people were in her comments wanting to know or whatever. And she's like, well, if you just simply have to know, then you can go to my likes. And she even said something like, if it's not real, Meg Thee Stallion should sue. If it's not real, Meg should sue. So the person who made it. So, that is a civil cause of action. That was civil. Like, you could sue somebody for it. Well, y'all, this is just a public announcement I want to make. I found this out today. It's a crime. It's a felony now. It's a felony now as of 2025. And again, this whole thing, what Milagro was found to be supposedly, liable for or whatever, she did that before this was a law, before this was a thing. So I don't want anybody out here saying, well, if she got held liable in civil court, doesn't that mean it's a crime too? No. Because this was not even passed until the spring of 2025. And she supposedly did the promoting, which would be the go to my likes statement, like all the way back in 2024. So no, I'm not in any way accusing her of a crime. I also think that this law in general, let me just tell you my opinion right here. I think this new statute has very serious constitutional implications, and they're going to pick on somebody with this law who is going to take it all the way up to the Supreme Court on First Amendment grounds, because I don't understand how something can be public on Twitter. Something can be public on Twitter. Elon Musk ain't getting in trouble for it, but one girl that says go to my likes for liking it did. There's 4,000 other heart reacts on it, and the one person you just trying to pick on who's commenting on something public, I understand and respect that a jury did find her to have violated that law. I understand and respect that. I'm not even trying to say I disagree with that finding. But what I am trying to say is I'm not sure that the actual statute is constitutional. For example, if a local little city decided to make a law where no Black people could go into the city hall, they could do that. And then if a Black person goes into city hall, they could be arrested. That could happen. But if that same Black person whose constitutional rights had just been violated could sue the hell out of that city and say, y'all got racist laws. This is not equal opportunity. This is not equal protection under the law. This is discriminatory on its face, and sue the city and win a lot of money. So why? Why is that? Well, because by making that law that said a certain race of people couldn't go into a public building that their tax dollars pay for, you've discriminated in an unconstitutional way. It's my opinion that this Florida statute that allows you to sue somebody who promotes a deep fake, but the deep fake is on a public website that anybody could be looking at, I think you should also have to tag that on to like the publisher, the person who actually published it, the account that it was on, for example. So that's just my opinion, okay? I'm not a lawmaker. But here's another new law, y'all. This one is it's a crime. This time it's a crime. Look at this. Florida House Bill 757 makes deepfake and AI child blah blah a felony. Which, look, the child one, you're not going to get any pushback from me. You are not getting pushback from me. I think anybody who heart reacts the child one should go to jail. That's nasty. I'm not talking about children. But we're talking about, in the Milagro case, it was Megan Thee Stallion who's wop, 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 macaroni in the pot, wop, wop, hottie with the body at the at the Kamala Harris rally. I mean, she's kind of thrust herself out there as like a sex object. I mean, I didn't do that. I didn't thrust her out there as a sex object. She did that. She's in a song called Wet Ass Beep. I can't even say it. It's so hyper S, you all. You can't even say it in mixed company. I couldn't even say it in front of my own family. My father-in-law, I would blush. Okay. So she kind of is the one that thrust herself into that lifestyle. Okay. But anyway, so this is a public service announcement. Okay. This is not legal advice. Florida deepfake AI law significantly tightened the criminal code surrounding digital S crimes. The new law directly addresses the explosion of artificial intelligence technology used to create fake sexual images or videos. And this is depraved. This is messed up. People shouldn't be doing that. It's nasty. Deepfakeography, once existing in a legal gray zone, is now specifically a crime. As a criminal defense lawyer practicing across the state, this is MUSCA, MUSCAlaw.com, MUSCA law.com. He says, I'm a criminal defense lawyer practicing across the state. I've already seen the enormous impact. This article just came out in September, 3 months ago, not even 3. He's already seeing the enormous impact of this law on ordinary people who find themselves accused of creating or even possessing this type of content or even possessing this type of content. If you are facing charges, the stakes couldn't be higher. A conviction means a felony record, possible prison time, and lifelong consequences on your career and reputation. So yeah, it's a S crime, like maybe even like going on the registry stuff. This is where having private representation makes a difference. Okay. So what does this House bill actually say? It amends the Florida criminal statutes to add explicit language on digital S crimes involving artificial intelligence. The law criminalizes creating, distributing, or possessing non-consensual, sexually explicit images or videos generated by artificial intelligence, computer simulation, or digital manipulation. A person who willfully and knowingly creates or distributes or possesses, okay? Creator, distributor, or just in possession. Generated in whole or part, has to be sexually explicit, generated image or video. Give me a picture. You could have a screenshot of an AI corn. That's a felony. All it has to be doing is depicting an identifiable person without that person's consent. So all those Taylor Swift meme images that were going around, that's a crime to even have on your phone in Florida. Even though it was public. Slippery slope when people are being punished for social media stuff. Or like, in a situation where it's like, what if Milagro wanted to take a screenshot of something to bring it to her expert? What if Milagro wanted to take a screenshot of something to bring it to a digital forensics expert? What if she wanted to download? Let's say she never said, go to my likes. Let's just say she was doing an investigation because she's an investigator into is it real or not? And again, nothing Milagro did is a crime because this didn't even exist. Okay. Nothing she did is a crime. I don't even think this law is constitutional. I don't even think it's constitutional because they're punishing people for like commenting on public stuff. That don't feel like constitutional to me. People are saying I would appeal. I mean, if I had unlimited money, sure. But like, I'm sure she's just ready to move on from this crap too. I mean, she's got all this other money she's got to spend. But this is what the law says. A person who willfully and knowingly creates, distributes, or possesses any of these, create, distribute, or possess any sexually explicit. So that don't even say corn. That could just be one person in the room, it could be, the statue of David for all we know. Or video generated in part or whole or part through artificial intelligence or other digital simulation technology, depicting an identifiable person without that person's consent, commits a felony of the third degree. Now, all that I said, if somebody was making that of me, I'd be ready to sue them down, and I would hope they would get arrested. So, on the other hand, like devil's advocate, just saying, I could see why they want to crack down on this stuff, because especially with the kids stuff, if you're making, possessing, creating, intent to distribute or not, if you have a picture of that on your phone, I'm almost like put you under the jail, fam. Puh, yuck. Of AI, child in a something like that. No. But it does make it hard. I mean, I learned this in the Nova situation. It's like, obviously, I did not ever in any capacity at all share any of that with anybody except the federal and state authorities. And when I tried to call the LAPD, they didn't even give a shit. So I did share it with FBI. I did click the link and share it to Twitter to tell them to take it off. I did not share that with other people. But after day after day after day went by, I was just sitting there hopeless and helpless. There was nothing I could do. I couldn't say, hey, everybody, go report the page. Because first of all, I would never, ever, ever want y'all to have to endure seeing that, because it's nasty and it does something to your brain in a messed up way. It's very traumatizing to see a child in that type of situation. I don't think this was AI. So obviously I wouldn't send people over there to go report it. But like, it just, if you were to do that, for whatever reason, then now you're promoting it, which is a huge crime. And it's like, you're really damned if you do and damned if you don't, because you just have to sit there on your hands and hope that the authorities and the powers that be do something about it, because you certainly can't. Nothing is a very helpless feeling. And so it's hard to know, like, okay, yeah, go to my likes is not the same thing as trying to report something to the FBI. I understand that. But like, I don't want to share it, but you can go to my likes because it's public. It seems like something that somebody would just be free to do. But again, this is a new law. So I wanted to put y'all on notice. Not only that it's a civil law, you could get sued, but also it's a crime. So before y'all telling people to go to your likes, before y'all telling people, oh, look, here's this, sharing it on a DM, sharing it in a WhatsApp, I know y'all know by now, all of that is discoverable. All of that can be, if you don't turn it over, then the Twitter can turn it over and stuff like that. So obviously, I know nobody would be doing anything like that from a malicious way that's watching my channels. If you would, and you are doing that, I'll testify against you because you're nasty, and that's nasty. Like, I wouldn't do that. There's a reason that I never shared that fake, what I believe could have been real. Truly, it could have been. I don't know. I didn't do too close of an analysis. Okay. But what I believe is fake AI pornography, which was sent to me in order to make me share it so that they could sue me under these, these statutes or whatever, try to act like because that's the thing too. She had said in her lawsuit against me that I shared fake pornography of her or something. Like, she said I did it as if I did. She said I did it as if I fell for the trap. That's what made me think another reason made me think it was some type of trap. And maybe it wasn't. I don't know. Maybe somebody was just like, really, on corn website, whatever. I don't even remember which one it was, but we one of them corn websites. And like, she sent me, pictures and stuff. And it's like, well, shit, like that was definitely a setup, but it was public. Like, it was a public thing. And it's difficult now in this day and age to know if something is real, if something is fake. And I do have a video coming out on this. I made actually a Megan Pete versus Milagro Grams BJ Investigates to just kind of encompass the whole trial into one video, kind of like my thoughts and things like that. And that's one of the things that I did say is, I lost my train of thought. I was reading y'all's comments. Oh, yes, Puffin. Thank you. This reminds me of what I was going to say. Where was this energy for Perez Hilton when he was taking pictures up Britney Spears' skirt? When they were taking upskirt pictures of Britney Spears, Paris Hilton, Kim Kardashian getting out of cars, when there was 200, 300 paparazzos gathered around Britney Spears when she was just trying to be a young mother, and they're taking pictures of her shirt falling down and her this and her that, and saying that was really her. That wasn't AI. It was really Britney. It was a real person. That was a real person. Where was all this energy when the mainstream media was ruining generations, not just one person's life, all of our lives? They were traumatizing all of us by putting that stuff. We couldn't turn it off. That was mainstream. Milagro, me, other, you can go to our channels or you cannot. No CNN or NBC is really pushing us. And shout out to her. She did get her recent, what do you call press run? She did. And shout out to her for that. But like, where's all this energy for Harvey Levin and Perez Hilton when they were putting pictures? What about the Paris Hill one night in Paris, and then the tape that Kim and Ray J did together? That wasn't even AI. That was real. And people were sharing that. Nobody got sued for that. Nobody got found guilty for a crime for that. It's only whenever people are saying click and like on Twitter and saying go to my like, then all of a sudden it's a law. I think it's weird. I think it's weird. Anyway, that's all I really had for this one, y'all. Cupid's bow, you bet they started a file on me already before her daughter's video. Well, I mean, that's fine. They can have a file. I don't do nothing wrong. So two can have a file on. Two can play the I got a file game, baby. I ain't messing with them. They don't want no smoke. Yeah, that other generation of celebrities, they did have it bad. People were sharing that clip of Drake. And what about Shannon Sharp? People were sharing that. So anyway, that's all I really had for this one. In the meantime, facts ain't defamation. Neither are opinions. I do not know these people. I do not know anything. I do not know what I'm talking about. Please double check everything I said. Love you, Mina K. Bye.